Right. Good afternoon, and thank you very much for joining us on an EU perspective on the anniversary of the ECHR. I am very pleased to be able to introduce you to our three speakers today. First of all, Ms. Markella Papadouli, who is the coordination of the litigation strategy for the AIRE Center, which is a center that has been that has played a prominent role over the past decades in litigating fundamental rights cases in Europe, both before the ECHR, the European Court for Human Rights, and the Court of Justice of the European Union. So I'm particularly happy and proud that we've been able to have a positive answer from the coordination of Europe's strategy, the coordinator of Europe's litigation strategy, Ms. Papadouli, who will tell us more about the challenges, interactions between the legal orders from her perspective as a practitioner, as a litigator. I'm also very pleased to welcome today Dr. Rizcallah, who is a lecturer also at the University of Saint-Louis, a visiting professor, and a postdoctoral researcher here in Belgium. She has written her PhD on the question of mutual trust, so I thought she would be the best person to give us an overview of her thoughts on the question of mutual trust as a point of tension between the member states, but also the member states of the EU, but also in the relationship between the EU legal system and the Council of Europe legal system in the context in particular of the European Convention and the European Court's case law on human rights. And finally, I'm very, very pleased as well to welcome Professor Tobias Locke, who is a professor of law at Maynooth University. And a few years ago, he wrote a paper that many of us have read, entitled "The Future of EU Human Rights Law, Is Accession to the ECHR Still Desirable?", which I think is a good time to reflect on again at a time when the negotiations in view of accession have been reopened. So I very much look forward to your presentations and to the discussion, and I immediately give the floor to Ms. Papadouli. Sorry. Thank you very much for joining us, Markella.
No problem, and thank you very much for this wonderful introduction, Elise. Thank you very much for the invitation, and it's a pleasure to be here today. As you have already realized, I am not in a position to share my webcam today due to a very temperamental internet connection. My sound may also drop as it has done in the beginning of this day. So if that happens, I please ask for your patience until I reconnect. So a few things about me. As Elise said, I am the AIRE Center's Europe Litigation Coordinator, and I'm a lecturer in asylum law and international refugee law at London South Bank University. I'm especially honored to be here today, although I'd much rather, of course, be seeing everyone in person, but in the circumstances, better safe than sorry, of course. And I'm especially glad to be here to celebrate the anniversary of the European Convention on Human Rights, because I work for an organization called the AIRE Center, Advice on Individual Rights in Europe, which is a legal charity based in England, which uses the power of European law to protect fundamental rights. And this is both the European Union law and the Council of Europe law. And we provide free legal advice in the framework of our mission. We provide free legal advice and representation before domestic and European courts, both the Court of Justice and the European Court of Human Rights. And we engage in what it's called impact-based litigation. Others call it strategic litigation. We think this is a rather military term, so we call it impact-based litigation. We also engage in training and capacity building and standard setting, and we have done significant amounts of work using as our main instrument the European Convention on Human Rights. My personal area of focus, I'm predominantly an asylum lawyer, and then I moved on to human trafficking. So my presentation today will be focused on asylum cases. Again, it's a wonderful occasion to be here today to celebrate this anniversary and see a little bit how the two courts have interacted with each other. One of the ways that we have pursued impact litigation in our work with the AIRE Center is litigating in parallel before the European Court of Human Rights and the Court of Justice of the EU. Sometimes we did this simultaneously and on purpose. This happened in our experiences as third-party intervener in this case, in some cases, and sometimes it's happened as behind the scene litigator and helper or supporter of certain cases, but it certainly produced very interesting outcomes. Today, I aim to highlight the relationship between the European Convention on Human Rights and EU fundamental rights by looking at how EU fundamental rights law has developed within the framework of the Court of Justice of the EU next to ECHR law as this developed by the European Court of Human Rights. Now, to put a little bit this in context, the European Court of and the differences between the European Court of Human Rights to set the framework for our discussion, as you all may be already familiar, the European Court of Human Rights ensures the success of the European Convention on Human Rights through defining minimum standards who are practical and effective and not theoretical and illusory, and ensuring that European Convention on Human Rights are not theoretical and illusory, as I already said. So applicants can bring actions against individual states if they have a complaint about the action or inaction of a state which has ratified the European Convention, subject to certain requirements such as, for instance, the admissibility criteria and exhausting national remedies. The European Court of Human Rights often relies upon EU law and CJEU case law in reaching decisions, especially within the framework of Article 53 of the European Convention on Human Rights. What is important about the European Court of Human Rights, and it's why we use it as much as we do, is that any national, not just the national of the Council of Europe member states, can bring a claim before that court. You don't have to be a national of one of the Council of Europe member states. You can be anyone present on the territory of these states, as long as you are within the Council of Europe's, the court's jurisdiction. On the other side, the Court of Justice of the EU is there to ensure the uniform application of EU law in all EU member states, settle disputes between EU institutions and national governments, and allows individuals and organizations to take action against an EU institution if they feel that it has infringed their rights. And of course, you know very well that it's possible to bring a case before the CJEU in two ways. First, indirectly through national courts who may decide to refer the case to the Court of Justice of the EU, the preliminary reference mechanism, and directly before the General Court if a decision by an EU institution has affected you directly and individually. That is less so the case in asylum, as we will see. The CJEU can decide on issues which fall within the remit of EU law. However, as you know, the Court of Justice case law has drawn extensively on the ECHR and the case law of the European Court of Human Rights, even though it retains its own, let's say, sovereignty or independence by reiterating the principle of primacy of EU law and autonomy of EU law in many of its judgments. See, for instance, case 588 of the Court of Justice of the EU, reiterating exactly that, declaration of independence, if I may, of EU law. So today I will talk about cases in asylum that were litigated in parallel. And that, when I say in parallel, I don't necessarily mean time-wise. There may be a difference in the issuing of judgments of a year or so, but in parallel regarding the themes. So today I'll talk about the safe third country concept in asylum cases. I'll talk about detention, and I will talk about procedural guarantees. The original version of this presentation was a lot longer, I have to say, but I had to cut it short in order to allow maximum space for discussion at the end of it. So I'm going to start with my favorite topic, which is the safe third country concept. And the safe third country concept was one of the first issues that we came as prominently in the comparison between the two jurisdictions. So for instance, in the European Court of Human Rights legal realm, we have the rock star of all asylum cases. You may all have heard it, regardless of what area of law you may practice, is MSS versus Belgium and Greece, a case against Belgium and my home country, which concerned applicants and applicants' expulsion from Belgium to Greece under Article 34 ECHR. The court, the applicant in this case, had complained in respect of Belgium that his expulsion to Greece violated Articles 2 and 3 of the Convention. And in respect of Greece, the applicant alleged that upon return, he would face a real risk of treatment contrary to Article 3 of the Convention. Now, the court in MSS versus Belgium and Greece found violations of Articles 3 and 13 in respect of both Belgium and Greece. And the Grand Chamber reversed the conclusive presumption under the Dublin regulation that existed until that moment, that member states and certain third countries are safe as a result of having ratified the convention and the ECHR. So the court, in its assessment, said that the Belgian authorities, before returning someone to Greece, the applicant in that case, knew or ought to have known that the applicant had no guarantee that his asylum application would be considered seriously by the Greek authorities. And I pay particular attention to the wording of the court here, because we're going to compare it with the equivalent wording of the CJEU and see who did it better, if I say. So the ECHR said that Belgian authorities knew or ought to have known that the applicant had no guarantee in his asylum application. In a parallel case that the AIRE Center also intervened as a third party, first before the domestic courts and then before the Court of Justice of the EU, a similar matter came before the Court of Justice of the EU under a reference for a preliminary ruling under Article 267 of the TFEU, made by the Court of Appeal of England and the High Court of Ireland. And the main issues in NS&ME was the extent to which the respondent states had an obligation under EU law to make an assessment regarding whether deportation to Greece would likely result in a serious violation of fundamental rights. And the question essentially before the court was very analogous to the assessment made by the European Court of Human Rights in relation to Belgium and MSS. So basically, is it okay to have a presumption of safety when the countries that are in question regarding return are either part of the Dublin regulation or are considered as a safe country? And the Court of Justice of the EU came out to say that EU law prevents the application of a conclusive presumption that member states observe all the fundamental rights of the EU. But how did the Court of Justice say that? It said it prevents the application of a conclusive presumption when member states cannot be unaware. So the Court of Justice of the EU used a double negative, cannot be unaware, next to the positive obligation phrased in a much more eloquent way by the European Court of Human Rights, knew or ought to have known. Was the CJEU more hesitant in that case in coming straight out and saying member states have a duty to go out proactively on their own and research safe third country concept? Or did the CJEU leave it to a more passive interpretation of this judgment, cannot be unaware, meaning there's such a big wealth of information out there that member states don't actually have to be proactively in the knowledge of certain information, but they just cannot be unaware? I think that you will find many opinions about these two parallel cases, and certainly when they came out, it stirred a lot of discussion. While both courts performed different functions, the Strasbourg court assessed the validity of complaints issued by the applicants, and the CJEU responded of two requests from two different member states for interpretation of EU law. It is clear that the CJEU was to a certain extent influenced by the ECHR in its decision. However, it is also quite clear to see that the CJEU was a bit hesitant to put the final, or a first nail, this is not a final, a first nail in the coffin of the Dublin regulation, which was under attack by the lawyers at that particular time in this string of cases that looked like MSS versus Belgium and Greece. And you may all remember that the outcome of the two joint judgments was returns to Greece under Dublin regulation were halted for a very long time after this, only to be resumed hesitantly 6 or 7 years later. The second case that I want to talk to you about, the second theme that I want to talk to you about, is another rock star, a rather more contemporary rock star of cases, is regarding the Roske transit zone in Hungary. And again, practitioners were looking to bring parallel cases before the two courts in order to see what will happen for many years. And we finally got the occasion in 2015 with judgments coming out in 2019 from both courts, quite happily. So in the first Rockstar case, you may have heard it because it was all over the news, at least in the microbubble of asylum. It's called Elias and Ahmed versus Hungary, in which the AIRE Center provided background support and co-representation alongside with the fantastic lawyers of the Hungarian Helsinki Committee. The applicants had arrived in Hungary and applied for asylum. They were held in the Roske transit zone for 23 days and were then sent back to Serbia based on a 2015 government decree listing Serbia as a third country. The European Court of Human Rights, in that particular case, held that the removal of applicants to Serbia violated Article 3 because of failure to conduct an efficient and adequate assessment when applying the Safe Third Country clause for Serbia. For failure, this was the mentality, to take into account reliable information regarding the risk of refoulement from Serbia, administrative deficiencies to assess asylum claims, or denials of the right to apply for asylum for readmitted persons. However, and quite shockingly for everyone who was involved in the litigation, the court found no violation of Article 3 in respect of the lawfulness of detention, arguing that the applicant's significant restriction of the freedom of movement was necessary in relation to their asylum procedures. And even more shockingly to those of us who were involved, that there was no violation of Articles 5.1 and 5.4 in relation to the Roske transit zone. Why? Because the court thought that the applicants were no more vulnerable than the average person in that particular zone, even though submissions were made that the applicants were potential victims of forced labor. They had human contact, and their short stay was, their stay was very short in that particular zone. I have to say that after Elias and Ahmed came out, and despite the good nuggets, pieces of law that we can find helpful for future cases, the practitioners involved were all a bit disheartened. And then very shortly after, there was a sigh of relief in the legal community because PPU, FMS, and others came out. This was a judgment by the Court of Justice of the EU, in which the applicants' asylum applications were denied as they had entered Hungary through Serbia. Return orders were issued for Serbia. However, upon Serbia's refusal to readmit the applicants, Hungary amended destination countries on return orders. The applicants were returned in the Roske transit zone, so exactly the same transit zone as the Elias and Ahmed ones, awaiting their expulsion. The Court of Justice of the EU in that particular case held that the change in the destination country should be regarded as a new return decision, requiring an effective remedy in accordance with Article 47 of the Charter. The national legislation provided for a safe third country is contrary to EU law. Transit zone conditions constituted detention, and neither the Return Conditions Directive nor the Asylum Procedures Directive permit detention in transit zones exceeding 4 weeks. That was a really big finding, which on its face is contrary to that was issued a little bit earlier in the year by the European Court of Human Rights. The Court of Justice of the EU regarding detention said that detention should not be applied for the sole reason that an applicant cannot meet their own needs, and that the conditions of detention for a period exceeding 4 weeks, meaning the closed fences of the border zone, the barbed wires, the fact that the applicants had nowhere to go and they would suffer a penalty if they were to enter Serbia using an unauthorized entry, meant that the transit zone conditions constituted detention, which is unacceptable by EU law. So we see a very major finding, and while trying to explain the differences in approach in these two judgments, we come to the conclusion that the two courts use a different methodology in reaching their judgments. The first court, so the European Court of Human Rights, uses a more case-by-case focus and looks more at the conditions for that particular applicant in this particular transit zone and the length of their particular stay. Whereas the Court of Justice of the EU focused in reaching its decision on more abstract EU law rules, focused very much on the length of the detention exceeding 4 weeks, and ended up in this particular occasion providing with higher standards of protection that would apply across all EU member states. Does this mean that the Court of Justice of the EU on this occasion offers higher protection than Elias and Ahmed? I think that it would be too simplistic to say that. I think that Article 5 of the Convention and the jurisprudence that we have on Article 5 on the Convention generally allows for a more nuanced case-by-case assessment of the living conditions in transit zone on the basis of whether restrictions to the liberty of movement of asylum seekers exceed what is strictly necessary for the processing of their asylum application, which in theory could occur prior to the 4-week deadline set by the CJU. So does this mean that in the future we may have judgments that are closer to FMS in diverging from Elias and Ahmed if the facts are different? The answer is maybe. However, that doesn't explain in full, according to my opinion, the stark difference in the finding between the two courts about the same transit zone, because we're not talking about different transit zones, we're the same transit zone. And the conditions within the transit zones were similar for both cases. I will discuss more about the difference in these two alongside the end of my presentation. The last issue I'll touch upon with you today is the issue of procedural guarantees, and in particular, the requirement for personal interviews of asylum seekers. Again,
if I may, Markella, ask you to just perhaps process this last bit of information a little bit more quickly so that we can then have time for discussion after this full panel, after this full presentation.
Of course. The last bit of that I'll close with my presentation with is procedural guarantees. And in Asadi, the applicants were found in a track by the Slovak border. Individual decisions on administrative expulsion were subsequently issued, as well as a 3-year ban on re-entry. And the applicants complained that the removal to Ukraine amounted to a violation of Article 4, Protocol 4. And the European Court of Human Rights found no violation of Article 4, Protocol 4. And the fact that they were given personal individual interviews was crucial to this finding, even though the interviews that they had arguably were not enough, only lasted 10 minutes, and the judgment passed by a very small margin of 4-3. In the contrary, in Addis versus Bundesrepublik Deutschland, the Court of Justice of the EU looked at the interpretation of the Procedures Directive and the consequences of failure to conduct a personal interview prior to an inadmissibility decision, holding that interviews are absolutely necessary because they assess the levels of vulnerability of an asylum seeker, thus offering a stronger level of protection of the safeguards, the right to personal interview, which arguably was undermined in the judgment of Asadi and others versus Slovakia, and previously had been further weakened by another judgment of the court, Claifia and others versus Italy. I will skip ahead to the limitations of the CJU, and that can be summarized to the fact that it appears that its scope is a bit more narrow. So it can uphold fundamental rights if the circumstances fall within the mandate of EU law. The court appears to be more restricted. The judgments are a bit more difficult to implement, more abstract, and if I may, a little bit more difficult to comprehend. And sometimes the court refrains from giving concrete answers to preliminary references and provides with limited rationes decidendi, possibly because it wants to avoid getting involved in national disputes. So if I may, the CJU appears more like an oracle sometimes, rather than giving the concrete answers that sometimes we seek in questions. On the other hand, the advantages of the European Convention on Human Rights is that it has a somewhat wider jurisdiction. And again, I explain why that is. It's a specialized human rights court in that it has an extensive experience in human rights law, and it provides with a system of human rights protection that is unique, I think, in the whole world in this respect. It's a living instrument, and it provides a possibility of checking the conformity of EU actions within the ECHR, although the ECHR has stressed that it does not prohibit state parties from transferring their sovereign power to an international organization, but the that court itself is not stopped from reviewing a member state's action which are at odds with the human rights protections embodied in the convention. That was said by Matthews, another judgment. So what do we need in order to make these systems, and this I'm coming with this, these two slides to my concluding remarks. We need a well-managed dialogue between the two courts in order to enhance the fairness and predictability. This would also benefit the beneficiaries, so the clients that we work for. Definitely the divergences in interpretation lead to inconsistencies and uncertainties, and that cause problems both on the side of states who are not sure about what the standards are, but also on the side of clients who are not sure what their rights and the protections that to be afforded are. The CJEU has declared potential EU accession agreements to be incompatible, but then we will hear from our next speakers regarding the accession agreement. But my argument, the thought that I would like to leave with you today is that the CJEU has not established yet a comprehensive fundamental rights policy. However, as the current standards and as the standards of protection between the Strasbourg court and the CJEU court vary, states must check if the application of a rule is proportional and reasonable imposed by EU law, or it would infringe the European Convention on Human Rights. A lot of academics, you will see, continue to argue that the CJEU should increase the visibility of this right by emphasizing its reliance on the Strasbourg court, as well as other systems. But, and this is an argument that we hear very, very much in academia, and I don't think that is necessarily right. This is necessarily wrong. But if we have, at the end of this presentation, to answer the question, which court is better for human rights protection, I will answer like a lawyer and say that it depends. One thing is for sure, better dialogue and better interconnectedness without egos between the two courts will help both advance justice as well as give further legal clarity in a crucial human rights time issue as the one that we need now, that we are living now, and this is very, very much needed. Thank you very much, everyone, and Elise, and I'm sorry if I abused the time.
Thank you very much, Markella, for your presentation. You didn't abuse anything. I just wanted to make sure that there would be a bit of space at the end for some discussions. And in fact, that's an opportunity for me to invite our audience to send any questions they may have through the chat, specifying to whom the question is addressed, so that as the speakers are speaking one after the other, I can also already start organizing our Q&A. Now, in the meanwhile, I think it's now time to hear Dr. Rizcallah on the question of mutual trust, and I think now is a very good time. Some of the cases perhaps were already introduced by Markella in her presentation, and Cécilia, it will be very interesting to have your more systemic view on this question of mutual trust. So we look forward to listening to your presentation. Thank you very much.
Okay. Thank you, Elise, and thank you to the organizers for having me today. Do you see my slides? Do you hear me?
Yes, we do, and we hear your slide, and we see your slides.
No, I just verify. Okay, so thank you, and yes, indeed, there will be some links with the previous presentation. So I will be speaking about the compatibility of the principle of mutual trust in union law with the requirement of the convention and among others in the asylum field, which was already introduced by Markella. So after a brief introduction, I will remind what are exactly the obligations under the principle of mutual trust in EU law. And then I will analyze what are the requirements of the convention in the context of international cooperation between states, and more precisely, when applying the principle of mutual trust in EU law. And I will finally put forward the hypothesis that in the current state of the case law of both courts, a path for harmony between the requirements under the principle of mutual trust and the convention is reachable. But first, I would like to remember that at first sight, the relationship between the principle of mutual trust and the convention is not one of conflict, Quite on the contrary, actually, the principle of mutual trust is based on the presumption that member states of the EU respect the convention, since it is based on the presumption that all member states share the values stated in Article 2 of the TEU, which include human rights as protected by the EU Charter of Fundamental Rights, but also by the convention. Yet, in its opinion 213, related to the accession of the EU to the ECHR, the Court of Justice found that there could be a conflict between the principle of mutual trust and the convention. And this was one of the main arguments the Court of Luxembourg put forward to justify its negative opinion on the project of accession treaty. This is, of course, rather puzzling because the principle of mutual trust is presented as entering in conflict with one of its foundations. And this is what I'm going to analyze more in depth now. So in order to do that, I will first remind what the principle of mutual trust in EU law exactly implies. So when applicable, because it doesn't apply, it is not always applicable, but when it is applicable, the principle of mutual trust imposes to member states within their direct horizontal relationships to presume the respect by the other member states of European Union law, including fundamental rights. In practice, it thus prevents member states to control the respect of union law by the other member states when collaborating with them. There is a presumption of compliance. This principle plays a fundamental role in EU law by enabling swift and smooth cooperation between member states when governing the European area without internal borders. However, this principle also constitutes a source of risk for fundamental rights. Indeed, the absence of double control of the respect of fundamental rights can lead to the spread of legal solution which violates human rights across the European area without borders. And we find, of course, here the possible source of tension with the European Convention on Human Rights. Nevertheless, it must be observed that the presumption imposed by the principle of mutual trust is not absolute. It may, or even it has to be rebutted when there is a risk of severe violation of fundamental rights. I unfortunately do not have the time to go through all the judgment by the ECG, but the case NS, for example, was already introduced by Markella. But in summary, we can notice that the position of the European Court of Justice evolved and went towards an enhanced protection of fundamental rights in the framework of the application of the principle of mutual trust. Indeed, while the first judgments on the question seem to devote an almost absolute presumption of compliance by the member states with fundamental rights, for the sake of preserving the effectiveness of EU cooperation, the court more recently confirmed that this presumption should be reputed when there is a risk of violation of fundamental rights. And more precisely, it has to be rebuted, first hypothesis, when there is a risk of threat on an absolute fundamental right, such as the prohibition of inhuman and degrading treatment. This was, among others, confirmed in the CK case, also in the asylum field, in relation to the transfer of mentally ill asylum seeker on the basis of the Dublin system. Because of the risk of violation of Article 4 of the Charter, the transfer had to be suspended. Or, second hypothesis, when there is a serious risk threatening the essential content of a non-absolute fundamental right, such as the essential content of the right to a fair trial, which includes notably the principle of judicial independence. This was laid down by the European Court of Justice in the LM case, where it said that the execution of a European arrest warrant should be refused in case it was issued in violation of judicial independence. So in summary, if any risk of violation of a fundamental right does not justify to set aside the principle of mutual trust, the most serious one do. So now I will move to the second part of my presentation, which aims at analyzing the Convention's requirements applicable to contracting parties when they cooperate with other states. And this is, of course, to eventually assess the compatibility of the principle of mutual trust with these requirements. So as a matter of principle, contracting parties could be held liable indirectly for a breach committed by another state. This happens when the contracting party, first hypothesis, has made a violation of the convention possible upstream, for example, by extraditing someone to a state where she or he will suffer a violation of his or her fundamental rights, or when the contracting parties has given effectiveness downstream to a violation of the convention committed by another state, for example, by recognizing and executing a judgment issued by another state which violates the rights enshrined in the convention. So that is the second hypothesis. This principle also applies to member states of the European Union when they implement EU law. Indeed, as most of you must know, the action of member states made under EU law do not enjoy an immunity vis-à-vis the convention. Member states remain liable for their obligation under the ECHR even when they implement EU law, and this was recalled by the Court of Strasbourg in the Maynooth case. There is, of course, the so-called F.R.S presumption, which implies a presumption of compliance with the convention of member states' action taken without any discretion under union law. I won't go into more detail about this, but this presumption is neither absolute nor eternal, and it could therefore be rebutted when there appears to be a manifest violation of the convention. So to summarize the main points of the second part, the convention continues to apply to contracting parties when they collaborate with other states. This is also the case when the collaboration is made under union law. And again, this is why we can, the European Court of Justice found that there could be a conflict between the principle of mutual trust and the ECHR. However, when we analyze more in depth the case law of the European Court of Human Rights, it appears that the applicable standards are reduced in the context of international cooperation. Indeed, the Strasbourg Court has shown itself lenient with contracting parties in this field precisely in order to preserve international cooperation, which contributes, according to the Strasbourg Court, to the general interests. Therefore, indirect liability for the violation of the convention will only be recognized when there is a manifest breach of the convention. And the analysis of the case law seems to show that such manifest breach of the convention can be found, first hypothesis, when there is a risk of violation of an absolute fundamental right. This was notably confirmed by the Strasbourg Court in its judgment Othman Abu Qatada, where it held that the expulsion by a contracting state may give rise to an issue under Article 3. Indeed, Article 3 is absolute, and it is not possible to weigh the risk of ill treatment against the reason put forward for the expulsion. So that is the first hypothesis. Second hypothesis, which can trigger the indirect liability for a breach of the convention, is when there is a manifest deficiencies in the protection of a non-absolute fundamental right, when there is a risk of violation of the substance, the essential contents, the core guarantees of a non-absolute fundamental right. The court also specified what this threshold meant in relation to Article 6 of the Convention. According to the court, this threshold will be met when there is a flagrant denial of justice, which is able to trigger the indirect responsibility of a contracting state, and such a flagrant denial of justice goes beyond mere irregularities or lack of safeguards in the trial procedures, such as might result in a breach of Article 6 if occurring when within the contracting state itself. What is required is a breach of the principles of fair trial guaranteed by Article 6, which is so fundamental as to amount to a nullification or a destruction of the very essence of the right guaranteed by this article. End of quotation. This line of case law shows that if contracting parties remain liable for ensuring the effectiveness of the convention when cooperating with other states, the European Court of Human Rights also recognized a reduced effect of the convention in this context, justified by the aim of preserving international cooperation. This makes me move to my third point, the reception of the principle of mutual trust as such by the European Court of Human Rights. And we must note that the European Court of Human Rights does not depart from the principles I just explained in this context. The court indeed seemed to consider that a breach of the convention resulting of the application of the principle of mutual trust could only be found when there is a particular serious violations of the rights enshrined in the convention. For example, the court underlined in its decision, Ignua and others, that mutual trust and confidence underpinning measures of police and judicial cooperation among EU member states must be accorded some weight. Indeed, this reflects the court's own general assumption that contracting states of the Council of Europe will respect their international law obligations. This presumption is, however, of course, not absolute again, and recent case law of the Strasbourg Court shows when it has to be rebutted. So the European Court of Human Rights explained its position very widely in its Advotin's judgment, where it held that mutual trust had to be set aside if a serious and substantiated complaint was raised, showing the existence of a risk of manifest breach of the convention. If we analyze the case law of the court more in depth in relation to the principle of mutual trust, there seems to be such a manifest deficiencies. On the one hand, when there is a clear risk of violation of Article 3 of the convention in the country where the person could be surrendered, either due to the existence of systemic deficiencies in this country. This was the situation in the MSS case, which was explained by Markella, or due to the particular situation of the concerned person. And this was met in the Tarakel case, where risk of violation of Article 3 of the Convention arose from the vulnerability of the asylum seeker concerned by the Dublin transfer. On the other hand, manifest deficiencies may also occur in relation to non-absolute fundamental rights, of course, and in particular in relation to Article 6 of the Convention in presence of a risk of flagrant denial of justice, or in other words, a risk of impairment of the essential content of Article 6. So again, it seems that member states could be held liable for the breach of the convention when implementing the principle of mutual trust, but only if there is a very severe violation of the convention. On the contrary, it seems not that any violation of the convention could lead to an indirect responsibility of EU member states. This brings me to my conclusion, which puts forward the hypothesis that a harmony could be found between, on the one hand, the requirements of the principle of mutual trust, and on the other hand, the requirements deriving from the convention. Indeed, for both legal orders, international cooperation, or in EU law words, trust, should be set aside when there is a serious risk of violation either of an absolute fundamental right. This was confirmed in the CK case and in the Tarakel judgment, or of an essential content, the essential content of a non-absolute fundamental right, such as confirmed in the LM, Drozden-Januzek and Pirosi judgment. However, this harmony can only be found under the condition that mutual trust is not applied automatically and mechanically. as underlined by the European Court of Human Rights in its 14th judgment, referring explicitly to the European Court of Justice. So national authorities must remain able to offer an effective remedy when serious and substantiated complaints are raised before them. Lastly, I want to briefly speak about a recent judgment of the European Court of Human Rights, where the harmony between the principle of mutual trust and the ECHR was fully illustrated, and even a kind of complementarity. It's in French on the slides because the judgment is not translated. And I unfortunately do not have the time to go into more details, but the European Court of Human Rights found that Belgium had violated the convention, and more precisely Article 2 of the convention, the right to life, by refusing the execution of a European arrest warrant, and thus by not applying the principle of mutual trust. Indeed, because of this refusal, which was according to the Strasbourg court not sufficiently justified, the procedural rights of the victims concerned by the offense were breached, and the refusal to cooperate therefore resulted in a violation of the procedural guarantees deriving from Article 2 of the Convention. So there we see an illustration of the complementarity of, on the one hand, the principle of mutual trust, and on the other hand, the European Convention on Human Rights. Thank you for your attention.
Thank you very much for your presentation, Cécilia. I think it was very useful to have yours following up on the one by Markella, who had focused really on the relationship between the two in the field of asylum and her own perspective as a litigant. And then you broadened a little bit the discussion looking at other areas of EU law, which also are closely sensitive from a fundamental rights perspective, concluding in particular on that one, on European criminal law in the Castano case. So I'm pleased to now move to the presentation of Professor Tobias. Thank you very much also for joining us. And again, zooming out, I'd say even more, and asking the big question about accession. And we look forward to hearing your thoughts, Tobias. Thank you very much for joining us as well.
Thank you so much. I hope you can hear me, and I'm glad to be back in Leuven, albeit virtually. So I want to talk about accession to the ECHR, which is on the cards again, and negotiations have restarted, I think, in June. So it's a live topic after a bit of a hiatus. So here's what I want to talk you through. Briefly, why do we still want it? What are the problems? What are possible fixes based on a leaked document from the Council? So that's what, at least the EU's view, we have an idea of what they want. And then I'm going to look at the AFSJ mutual trust as well. And it's great that we've had two great presentations on that topic already, so I can just pick up on that, and then we'll see what our conclusion is. I'll leave that open. I'll leave that for the discussion. So why do the EU and the ECHR high contracting parties still want to pursue accession to the ECHR? It's clear we have a legal obligation still in Article 6.2 of the TEU, which, according to Johan Callewaert, who's the Deputy Registrar of the Grand Chamber of the Court, represents the very idea of collective understanding and enforcement of fundamental rights. So there's this idea of collectivity, collective responsibility for the fundamental rights contained in the Charter and also in the Convention. And of course, the hope is that accession would eliminate or at least reduce the risk of inconsistencies and fragmentation, which does every once in a while pop up. And I think we've seen some examples of this already today. And finally, accession would close certain accountability gaps that we have at the moment. Now, we have the rule of Matthews, whereby member states can be held responsible instead of the EU for violations brought about by EU law, but there are two important exceptions. One is the Bosphorus presumption of equivalent protection, which the EU enjoys, and which can only be rebutted if there is a manifest deficit in the protection in the concrete case, provided, of course, that it applies, which is when a member state has no discretion in implementing its EU law obligations. And the second exception is what I call the Connolly gap, which arises from a lesser known case called Connolly, where we have no member state involvement in the whole alleged violation as it came about. So no member state institution, no member state court was involved at all. And this case was a staffing dispute between the EU and one of its staff members. And there we simply have no violation occurring within the jurisdiction of one of the EU member states, which is of course one of the key requirements, key threshold requirements under Article 1 of the Convention. So these two gaps would presumably be closed by accession. Certainly the Connolly gap and the Bosphorus presumption might not survive it long term. Now, the Court of Justice identified a number of problems in Opinion 213, which related to the draft accession agreement, and some of the, well, tricks and ways in which the drafters had come up with in order to circumvent some of the problems they anticipated. And the main problem, the main challenge really from an EU law point of view is the autonomy of the EU legal order, which means that the European Court of Justice for a long time has not allowed another court, another international court, to determine the exact delineation of competences between member states and EU, and to interpret EU law substantively in a binding way for the EU and or its member states. And in order to get around this, we had the co-respondent mechanism, which allowed the EU, would allow the EU and to join proceedings brought against the member state as a co-respondent and be held jointly responsible. A prior involvement of the Court of Justice in cases where the Court of Justice had not yet had the opportunity to rule on the matter because no preliminary reference had been made. There were issues with inter-party cases between the member states because Article 344 TFEU provides that EU law matters between member states are the exclusive purview of the Court of Justice. There was an incomprehensible issue about the two Articles 53, which I'm not going to go into. There was a problem with Protocol number 16 and whether this would allow member states to, or member state courts to circumvent the preliminary reference procedure. And then the two big problems, the exclusion of mutual trust or mutual recognition cases, which the Court of Justice demanded, and the exclusion of the Court of Justice's jurisdiction over common and foreign security policy measures, and how to get around how it took issue with the fact that the European Court of Human Rights would have jurisdiction over such measures for their human rights compliance, where the Court of Justice doesn't have jurisdiction because it's excluded under the EU treaties. Now, what fixes are there? I'll come back to the various issues and explain them a little bit more, don't worry. Now, my inspiration for this, for today's presentation, is something I came across only 2 weeks ago or so. I found this leaked document, which is a Council of the EU document that you can avail of on the State Watch website. And it basically outlines the negotiating position of the EU. There are two things the EU proposes to do, is basically to bring about accession to the ECHR on the basis of the old accession agreement, but to change it where necessary. And in addition, to adopt EU internal rules on various issues, which would also help with ironing out any of the problems that the Court of Justice has identified. Now, the first question, of course, is, and we won't find out probably for 2 or 3 years, will this be enough to satisfy the ECJ? That's always the open one. But the second question is more of a political one. Will these solutions, which would carve out bits of the jurisdiction of the European Court of Human Rights and treat the EU somewhat differently as a result, be acceptable to the non-EU member states in the Council of Europe, especially those that apply a lot of EU law, like Switzerland, Norway, and so on? And when we look at the statements these member states have made at the beginning of the resumption of accession negotiations in June and September, we can see that there's a theme. This is Turkey. They say, oh yeah, we're all happy about it, but it has to happen on an equal footing with the other 47 high contracting parties. Norway also highlighted the principle of equality, and Switzerland also spoke of the equal footing. So there is a certain alertness on part of the non-EU member states in the Council of Europe that they don't want to let the EU and the EU member states get away with certain arrangements that would reduce the human rights protection there, where at the same time that would lead to some sort of an inequality of treatment between the various parties to the ECHR. Now, let's look at the issues at the slightly more technical or easily fixable issues first, and then we'll move on to the CFSP and mutual trust, which are the tricky ones. Now, the co-respondent mechanism, as I said, would allow the EU to join proceedings as a co-respondent, and member states join proceedings brought against the EU as co-respondents in certain cases. Now, the original draft accession agreement envisaged a review by the Court of Human Rights as to whether a request to become a co-respondent was plausible, and that the Court of Justice said that's too much violation of the autonomy of EU law. So the solution is to remove this plausibility control and simply to give the EU and the member states an unconditional right to become co-respondents. And a second issue that there was that the Court of Human Rights would have been able to deviate from the principle of joint responsibility of co-respondent and respondent. And again, the Court of Justice took issue with that, and this has now been would be removed. Now, I don't have any problems with these suggestions, so there we go. Second issue was the prior involvement of the ECJ. Again, a power, if you wanted to call it that, by the European Court of Human Rights to check whether the Court of Justice had already dealt with the matter or not. Again, this was considered to be one step too far by the Court of Justice and endangering the autonomy of EU law, whether you believe it or not. It doesn't matter. It's there in the judgment, in the opinion. And the solution is obviously to make the prior involvement mandatory on the European Court of Human Rights, so the EU can unconditionally request sufficient time for the prior involvement of the ECJ, and that also had to be extended to questions of the interpretation of EU law, where the accession agreement only provided for the prior involvement on questions of validity of EU law, which was a drafting mistake, I would think, in hindsight. There was the further issue of inter-party cases and protocol number 16, where the Court of Justice says, well, if member states bring certain inter-party cases that are really about EU law, they're in violation of their duty under Article 344 TFEU and the duty of loyalty to bring these cases to the Court of Justice. That's the Mox plant case and subsequent cases that go into the same direction. And also protocol number 16, where member state courts, highest courts that ask the Court of Human Rights for an advisory opinion under protocol number 16 would be potentially in violation of their duty under Article 267 TFEU to refer the case to the ECJ. Both not particularly credible issues, again, identified by the Court of Justice in opinion 213, but the solution is quite an elegant one. According to the Council, they would say, well, there shouldn't be any inter-party cases between the EU and the member states, fine. And if there was an inter-party case or a reference under protocol number 16 brought, the European Court of Human Rights will be under a duty to inform the EU of that. That probably means the EU Commission, and the EU Commission can then instigate proceedings under Article 258, infringement proceedings under the treaties against that member state. And while these proceedings are ongoing, the European Court of Human Rights is under a duty to suspend the procedure. So that's quite interesting. And potentially problematic, but happy to discuss this later on. There is this obscure criticism that was levied by the Court of Justice that there was a lack of coordination between Article 53 of the Charter and 53 ECHR. I couldn't find anything in the Council document on that, so we'll see what they'll do about it. But the two big hurdles, I think, in technical terms and also for the question whether EU accession remains desirable, are how are we going to deal with the CFSP in the absence of giving the Court of Justice jurisdiction over all CFSP matters, which is out of the question on part of the member states. There's not going to be a treaty change in that direction yet or ever. And the second, of course, big issue of mutual trust, which I think is my personal worry, and we'll see what my co-panelists have to say about that, because they know a lot more about mutual trust than I do. So the CFSP, so the problem is that the Court of Justice only really has jurisdiction over sanctions measures adopted under the CFSP. All other CFSP measures, in particular operations under the Common Security and Defence Policy, would be outside its jurisdiction. Now, if we had accession to the ECHR, potentially the European Court of Human Rights would have the power to rule on the compliance of CFSP measures that are outside the jurisdiction of the ECJ with the Convention, and that the Court of Justice said cannot happen. So how does the Council propose to get around this? They say, well, we need a new clause in the accession agreement, and the trick would be to allow the EU to intervene in such a case and say, together with the member states, well, this case should not be brought against the EU, it should be brought against this member state or this group of member states. And the Court of Human Rights would be bound by that. So the case would be redirected against a different respondent, so to speak. And that, I think, if I understand it correctly, would be coupled with internal rules that EU internal rules that would establish certain criteria for which member states should be responsible in which scenario, which would then result in a suspension, a mandatory suspension of proceedings before the European Court of Human Rights in order for domestic litigation to take place in the member state designated, which would then allow some sort of the subsidiarity of the protection of the Court of Human Rights to kick in and allow this, the issue to be resolved within the member state, possibly allow for a reference to the ECJ, which would then have to determine whether it has jurisdiction, and so on and so on. My question is that convincing? I'm not sure about this. First of all, I'm not sure this is going to pacify the European Court of Justice, because it won't overcome the problem that the Court of Justice has not got jurisdiction over some CFSP measures. The second question I have is, what if there are no domestic proceedings in the member states, because member state courts don't consider themselves competent, they don't consider themselves to have jurisdiction over, say, extraterritorial adventures of their armed forces? I have no idea. So that's one solution possible, and that'll be an interesting one to watch. The other one is mutual trust, and I want to spend the rest of my presentation, my allocated time, on that. As we have seen, the Court of Justice took issue with the fact that there was no provision made for the preservation, if I want to put it like that, of mutual trust, of the principle of mutual trust, which is considered to be a fundamental principle of EU law, between the member states in the area of freedom, security, and justice. And it must be prevented, according to the ECJ, that the EU and the member states are considered contracting parties, not only in their relations with contracting parties which are not member states of the EU, but also in their relations with each other. So what the ECJ doesn't want to see is that cases are brought against a member state that is executing a European arrest warrant, for instance, and the argument being that the member state shouldn't execute the European arrest warrant because it is under duty of mutual trust, but that mutual trust is not justified given that the requesting member state has prison conditions that are awful and in violation of Article 3. That should not happen because it would undermine the autonomy of EU law. The Council's solution, I think, is this. There should be a new provision in the accession agreement that recognizes mutual trust as a fundamental principle of EU law, which may require each member state to presume that fundamental rights have been observed by all others, and may provide that judicial decisions have to be executed and recognized. And I think the consequence, that's not quite spelled out, if I see it correctly, would be to exclude ECTHR jurisdiction in certain mutual trust cases as a rule. Now, there are two questions I have. The first is, would that work at a technical level? Would such a provision actually do the trick? And I'm skeptical because there is such a thing that I would call the autonomy trap, If you are using EU law terminology in an agreement such as this, aren't you giving the European Court of Human Rights the power, the jurisdiction, the duty to check whether this is a mutual trust case, which requires the European Court of Human Rights to interpret EU law, which would fall foul of the autonomy principle? So there's that problem. The other problem, which is bigger, is would that be a desirable solution? And I have my question marks, because the AFSJ has become the busiest area of ECJ activity according to its annual report. We had 106 new cases in 2019. It is by its very nature particularly fundamental rights sensitive, as we have seen in the previous presentations, and therefore we would be excluding perhaps a large chunk of potential challenges in the European Court of Human Rights. Is that such a good idea? In particular, given that non-EU member states like Switzerland, that are also applying AFSJ measures, but just not as a member state, would remain responsible. So the principle of equality or equal footing coming back to haunt us here. That is the political question. But I think from a purely human rights perspective, I just think that the developments in the absence of accession haven't been quite so bad. And I think, that's what we've seen in the previous discussions as well. And if we look at asylum and refugee law, I think we can see it very, very nicely. We had the case of MSS, which was the first chink in the armor of mutual trust, where the Court of Human Rights said, look, if there's an Article 3 violation, you can't do mutual trust, at least not blind trust. It was then accepted by the Court of Justice in NS in a somewhat restricted manner, because the Court of Justice said, well, it's only when we've got systemic deficiencies and not just any old deficiency in an individual case. That was then codified in the Dublin III regulation, which is the main regulation in terms of allocating responsibility for asylum cases. It was then picked up again by the Court of Justice in the Tarakel case, by the Court of Human Rights, excuse me, in the Tarakel case, where the Court of Human Rights said, look, systemic deficiencies are not necessary. Any potential violation of Article 3 is enough to cause a human rights violation. You can't just hide behind mutual trust, which was again accepted by the Court of Justice in CK. And so we have this ping pong, this cross-fertilization, where the two courts have kind of figured it out reasonably well. My question is, would that have happened if we had had EU accession under the condition formulated by the Court of Justice in Opinion 213, where we need to exclude an awful lot of the mutual trust cases? I'm skeptical, at least I'm to be convinced by that. Why? Because I think the Court of Justice was acting under the Bosporus threat, the manifest deficit threat that was hanging over it like, the sword of Damocles in this painting there. And maybe if we remove that threat, especially in this very, very sensitive area of the AFSJ and of mutual trust, aren't we doing more disservice to fundamental rights protection in Europe than we are serving it by accession overall? And that is basically my conclusion. Is this privileging acceptable to non-EU member states? Is accession still a good idea? Or is this kind of pluralistic, more haphazard relationship that we have today the way forward? And thank you very much for this.
Thank you very much, Tobias, for your presentation. I'm really pleased, by how complementary I think the three presentations have been building one on the other. I'm very grateful to all three panelists for these very, very fruitful contributions, inviting presenting very nuanced and sharp, I think, analysis and views on the relationship between the two legal systems. Now we open the floor for a discussion. So I would like to invite the audience to write their questions in the chat. I will be selecting them, repeating them, and distributing them to our panelists. And it's wonderful, Markella, that you can now join with your camera. Welcome, also visually, on our panel. There is already one question in the chat that I will be pleased to pick up on. It is from Lucia van der Mullen, who is, I take the liberty of introducing her. She's a researcher at the Institute for European Law working on the project Reshuffle that looks precisely at the interplay between the EU legal system and the Council of Europe on fundamental rights question. And Lucia has a question that she addresses to Markella, the first speaker. And picking up on the way you concluded, Markella, by saying that you asked the question, which court is the best human rights court? And you say, well, as a litigant, I say it depends. And so it depends on the circumstances. And the question that Lucia is asking is, what are the criteria that you use as a litigant, as the strategic litigator, to pick up one avenue or the other, or perhaps to at least shape your argumentation in a way that could go to one court or to the other courts? And Lucia in particular asks, do you take into account the style of the court's judgments? Because it's something that you were quite critical about the Court of Justice of the EU. So is this something you take into account? And I would like to add to Lucia's question, if I may, do you also take into account the existence of a layer of EU legislation crystallizing the content of the fundamental rights? Is it something that can be a factor for you to decide one way or the other? I look forward to your answer as much as Lucia, I'm sure.
No problem. Good to be here as well in person. My camera may drop any moment, but my voice will be with you. So I think this is an excellent point. From an impact litigator perspective, I would say, first of all, there's not just two options. There's many options, okay? There's the collective complaints mechanism under the social, and then there's the UN mechanisms that are there. There's multiple UN mechanisms. There's Strasbourg, there's Luxembourg, and you know, of course, there are other avenues other than litigation. So we don't have just two. But so when a case comes to the AIRE Center and we have to decide which avenue we have to take, first of all, we look at the facts. So what are the facts? Are we looking at something that has been consistently addressed by one court? And so we would be looking to advance the jurisprudence. Is it something that we have already seen positive developments from one court? So it's an easier, let's say, win to take it to that court. So we do look at the prospects of success. Secondly, in order to take an issue to the Court of Justice of the EU, you would have to get a reference from a domestic court. So the things are a little bit more complicated. So first of all, we would see, is there any possibility or margin to convince the judge to make a reference? And that's not always a straightforward question in many jurisdictions. Then, of course, we would consider if there are layers of EU law that need to be addressed, or the deficiency of EU law that we need particularly be fixed. And that would contribute to us taking the case to the European Court. To the Court of Justice, sorry. I would say that it is something that it's a decision that has many factors that we take into consideration. We also take sometimes into consideration the length of the proceedings, although this can be quite unpredictable because, you know, we have the perception that sometimes the European Court of Human Rights takes less time. That's not always the case. We have some cases now pending before the Strasbourg Court that have due for years, 5 years or so. So that's not always, again, a straightforward answer. Do we take into consideration whether, for instance, we have a client who is not part of a structural problem or a systemic problem? So it's an isolated scenario, an isolated violation. Then yes, absolutely, this is something we would consider because perhaps the European Court of Human Rights would be a better way to address this other than an issue of lack of clarity of EU law. And then what was the specific point that the question was? Whether we consider...
So Lucia was asking about the quality of the judgments, because in your presentation...
Oh, yeah, I did say that. Yeah, that's absolutely right. I did say that the CJEU judgments feel sometimes like the oracle, in the sense that it's hardly written. It resembles, to me, the way that we write back in the Law School of Athens, so long sentences that go for 5 or 6 lines without a full stop, and that make them harder to read. So anyone who's trained in civil law will find this easier. I would say yes, but this is not a determining factor. That we do think about it, but the determining factor is, I think, would we be able to get a reference from the domestic court? Is this a matter of EU law? Is there a systemic lack of clarity in EU law in the jurisdiction that we litigate? What is the expected outcome? What are the facts of our case? How do we plan to fit that particular case within the framework of our general litigation priorities? And what are the other avenues and the impact that we want to achieve? Do we want to achieve a judgment that will change how how EU law is applied in the whole country? Or do we want to contribute to a string of jurisprudence produced by Strasbourg? So all of these considerations is the answer to the question, not a single factor.
Thank you very much for giving us an overview of the kind of criteria you take into account, Markella. I've received another question, which is addressed to Professor Locke, so to Tobias, from Carol Lyons. This person asked if the UK, which of course has always had a very ambiguous question, both on the EU, it's less than ambiguous by now, but also on ECHR membership, actually. So the question is, did the UK make any comments on the restarting of the accession process from an EU perspective?
Yeah, thank you very much. It's a good question. I just checked there briefly, and no, they didn't. But to be fair to the UK, I think there were only about 10 delegations that made a comment, and everybody else stayed silent. So you can't read very much into that. But the UK was represented. They were there. You may be pleased to hear, but we'll have to wait and see. I mean, I think rumor has it that the UK was one of the more difficult negotiators the last time around. How they will behave now that they're out of the EU, that it doesn't really affect them anymore, is hard to say. I would imagine that they'll probably be quite passive, but you know, that's just my guess.
Thank you very much for this. I have another question here, which I think could probably be addressed to both Cécilia and Tobias, but of course, if Markella wants to jump in, you're very welcome to do so. And it looks at accession and at these problems of jurisdiction over the CFSP, the Common Foreign Security Policy, as well as the area of freedom, security, and justice. Now, the way the accession process is going, if I understand well from your presentation, Tobias, because I hadn't seen any of these documents, so I'm very grateful for this update you gave us. It seems to be going in quite some technical details of how to technically address the problems created by accession. But I was wondering, could it be argued, I mean, would you believe, both of you, but also Markella, the three of you, would you believe an alternative narrative by which the Court of Justice would say, the Court of Justice of the EU would say, well, listen, on justice, on the area of freedom, security, and justice, there are no problems anymore. Our case law is now aligned on the ECHR. And an example, for example, would be, the Javot case on asylum, where the court sort of went even one step further, if I understood it well, to the ECHR case law on the kind of threshold that has to be breached to call into to trigger ECHR protection. And on the CFSP, the Court of Justice and some members of the courts themselves regularly write to say, well, in fact, the jurisdiction of the ECJ over the CFSP has been considerably expanding, using every single opportunity that there has been to give jurisdiction to the ECJ over various types of CFSP acts. Now, not all of them, of course, but at least expanding wherever it was possible. So could the argument be that in fact there are no major problems anymore, even at a substantive level? What are your views on this, or is that complete nonsense?
Who wants to start? Cécilia? No?
Okay, do you hear me? Yes, okay. Yes, so actually I completely agree with the finding that there is, so with mutual trust, I presented this hypothesis in my presentation that there is no more such a conflict. And for the CFSP, I think that in any case, the European Court of Human Rights can have jurisdiction, since all the measures are taken by unanimity. And so, I mean, you can apply the Matthews jurisprudence, and the European Court of Human Rights will be competent to judge upon this act. So there is no substantive problem, but no, if there is another opinion, the Court of Justice will have to justify it if it wants to do so, this change of its case law and of its position. And I don't feel that the Court of Justice will say that it made a mistake, and that now, actually, after thinking a bit about it, there is no problem. But at least for in regards the principle of mutual trust, the CJU could rely upon the last judgments of the ECHR being very lenient with the principle of mutual trust. So there was this decision in Noah and others. There is this Romeo and Castano case in Avotins. The Grand Chamber of the European Court of Human Rights specifically refers to the ECG by saying that now it's it's fine. So by relying upon these judgments, I think that the European Court of Human Rights of Justice, could find a way by a narrative to explain a change of position. But it remains a question to know if the Court of Justice wants to do so. That's another question.
Thank you very much, Cécilia. Does any other panelists have a view?
I fully agree with what Cécilia has just said. I'll be laconic, and I'll just say I have no problem with the hypothesis, but how realistic is it that this actually will be achieved as a consensus, and then how functional will it be once it actually gets implemented? I'd be very curious to see. But I don't find the hypothesis bad. To the contrary, I think this is a great thought. I don't know, maybe Tobias can be more optimistic.
I can't be really optimistic because we don't know until we know. And I think the Court of Justice had an opportunity the last time to find the accession agreement compatible with the EU treaties. I mean, that was, wouldn't have been too hard to do. The Advocate General at the time showed a way, at least in some areas, and I think the negotiators were acutely aware of all the pitfalls that there might be. So it's not like they went in blindly. So I think it'll come down to judicial politics of the day almost. And I mean, I just know anecdotally, again, I heard somebody who was on the court, or at least thereabouts, maybe not directly involved, but what the judges seem to say is, well, everyone was so celebratory. Everyone went in and said, oh, isn't it great? We've now got this agreement, and now court, you have to nod it off. And so they were annoyed about that. So maybe next time, the member states have to put more of an effort into convincing the court and how difficult it is, and that, and so on and so on. But I think, look, yes, I think the CFSP jurisprudence is certainly pointing in the right direction for the Court of Justice. It's carved itself a lot more powers than it had in 2013-14. With the AFSJ, I never fully understood the problems anyway, because you either sign up to an external mechanism of scrutiny or you don't, and I mean that always involves buying into the whole thing. And if that questions some of your assumptions that a lot of your rules are based on, then you may have to change the rules. I mean, that's part and parcel. And the problem is, of course, that the EU doesn't evade the scrutiny that way, because you can, as Cécilia said, you can bring these cases anyway. I mean, you just hold the member states responsible instead. So I think if the Court of Justice is prudent, and if the negotiators don't make any big mistakes, it should be possible. It should be possible to make it an acceptable accession. But whether that will happen or not, I think it is really it's more a political question than a legal question, and that's what it comes down to.
Yeah, thank you very much. And perhaps one final question as our session is slowly coming to an end, from Aliki Semerzi, if I pronounce the name correctly. I apologize if I don't. And the question relates to the type of rights that are being litigated. So perhaps this is a question for Markella, but maybe others also have thoughts. The question is, has there been a sort of a study and analysis of which rights or which areas are particularly controversial in terms of the relationship between EU and ECHR systems? So we discussed a lot of asylum cases. Cécilia mentioned also some European criminal law cases, the European arrest warrant, or even Avotin, which is more on judicial cooperation. But the question that it relates specifically to economic and social rights. Have there been any controversies and discussion on the role of litigation on economic and social rights, with of course the limitations that are inherent in the text of the ECHR, for example? But perhaps you want to comment on this, Markella, to start with?
Yeah, I mean, what I can say on this is that I'm not following any general trends regarding what types of disputes are going before the Strasbourg court and before the CJEU. But I can definitely say that anything that would fall under the hard shell of rights of the common European asylum system, so for instance, access to appropriate asylum procedures, which can fall easily under the umbrella of the right to an effective remedy, prohibition of refoulement, so that can be litigated under Article 3. We can also say that some of the rights that are covered under the Reception Conditions Directive, so access to adequate housing, healthcare, provision of adequate nutrition, right to education. Also, these are rights that are very hardly litigated, very hard in Strasbourg for severe deficiencies in key member states, including my home country, and have come before the attention of the Luxembourg court. So, in the field of asylum, I would say that for sure there are trends that are definitely falling between both umbrellas, both the EU law umbrella and the ECHR umbrella. In other areas, there are some discrepancies. So, for instance, in human trafficking, we see a lot of the disputes falling under Article 4 of the ECHR, and Article 3 sometimes the cases, but we do not see that many cases reaching the preliminary reference ruling procedure before the Court of Justice of the EU. I'm not sure why that is. Perhaps member states think that everything's clear regarding the EU anti-trafficking directive, but I do see a discrepancy there. But I think things are clearer regarding trends in asylum.
Thank you very much. Do you have thoughts or comments on this, Cécilia or Tobias? Nothing in particular. In that case, I'm just checking. There is one last question. Perhaps I can just pick it up as we have 3 minutes. To Professor Locke. You mentioned the idea of an autonomy trap. Do you think that there is another trap, which would be that Opinion 117, after Opinion 117, where the ECJ accepted the CETA ICS under the autonomy of EU law, on behalf of the autonomy of EU law, then as a consequence, it could be accepted that the ECHR jurisdiction would have to be tolerated in the context of the EU legal system?
Yeah, thanks. I think, yes, I think Opinion 117 has probably softened the ECJ stance a little bit. You know, I mean, they're now accepting that another court can at least interpret the agreements that it was set up to interpret, and they are also accepting that you know, another court can be in charge, so to speak, of an agreement concluded by the EU. In that case, it was CETA, and so I don't know why that would be a trap. I mean, it might just be a good opportunity for the court to maybe reconsider its strict stance in Opinion 213.
Thank you very much. I think on these exchanges, I will be closing not only this panel, but also this conference. And I really want to thank the panelists, Markella, Cécilia, Tobias, thank you so much for having accepted to contribute to these reflections. And again, I'm really very grateful for the way it's been such a complementary and fruitful session. I would also like to thank more generally the organizers of this conference. This conference was organized with the support of, well, in the context of the Reconnect and Reshuffle project, among others, with the support and the very good collaboration with our partners, the Association of Human Rights Institutes and the European Society of International Law, to whom we are very grateful for this fruitful collaboration. And I would also like to stress, as you may have heard earlier, that this conference is the outcome of a large-scale collaboration at the level of the Faculty of Law of the KU Leuven. It brought together the Department for Public Law, the Center for Global Governance Studies, and the Institute for European Law on the initiative of the Dean of the Law Faculty and, importantly, Professor Jan Wouters. So I really also want to thank, in particular, Jan Wouters, I think, who's been really taking the lead in bringing us together and in being so patient with all the moderators for each panel, trying to compile all this in difficult circumstances, with this request to do this online with some sort of emergency and last minute issues coming up. So a great thank you for having being ambitious for us, Professor Wouters, and a great thank you to all the speakers of today, to the colleagues who put together the panels, to the law faculty and all those involved. Thank you also to our audience for your questions and listening so carefully. I wish you a lovely evening, and I look forward to seeing you in Leuven very soon. Thank you. All the best. Bye-bye.
Thank you very much. All the best. Bye-bye.
Thank you.